Formal judicial proceedings typically means the point of indictment, or the first formal court appearance like an arraignment or preliminary hearing after charges have been filed. It signifies that the government has formally committed to prosecuting the individual for a specific crime. The adversarial process has officially begun. Once it attaches for a specific offense, it applies at all critical stages of prosecution for that offense. These are any steps where a lawyer's presence is deemed necessary to protect the defendant's right to a fair trial. And, importantly, police have no obligation to inform a defendant that counsel has been trying to reach the defendant until this Sixth Amendment right has attached. This is different from some state laws, but under the Sixth Amendment itself, the trigger is the start of formal proceedings.
So it's not like Miranda where it's about the custodial interrogation environment. This is about the formal start of the adversarial process against a specific individual for a specific crime. What are these critical stages versus non-critical stages that you mentioned? This distinction is absolutely vital for the bar exam, knowing when the right applies.
It truly is. Knowing this list is paramount for issue spotting. Critical stages where the Sixth Amendment right applies once it is attached include post-indictment lineups and in-person identifications because of the high risk of suggestiveness and the difficulty of reconstructing it later without a lawyer present. It also includes post-indictment interrogations by police or informants acting as state agents. It also applies at arraignments, preliminary hearings where important defenses might be lost, bail hearings, pretrial motions where legal arguments are made, plea negotiations and the plea hearing itself because of the crucial decisions and waiver of rights involved, and of course the trial itself and sentencing. These are all points where a lawyer's expertise is seen as crucial to navigating the adversarial system.
Okay, what about the non-critical stages? Where does the right not apply?
Non-critical stages where the Sixth Amendment right does not apply include pre-charge or pre-indictment lineups and photo array identifications. These happen before the formal adversarial process begins. Also, procedures involving non-testimonial physical evidence like fingerprinting, taking handwriting or voice exemplars, or drawing blood samples. These don't require counsel under the Sixth Amendment. Additionally, initial appearances, often just for informing of charges and setting initial bail, hearings solely to determine probable cause to detain the defendant after a warrantless arrest, Gerstein hearings, discretionary appeals the court doesn't have to take, and post-conviction proceedings like parole or probation or revocation hearings are generally considered non-critical stages for Sixth Amendment purposes. The rationale is often that these stages are either purely investigative, ministerial, or occur after the core adversarial trial and sentencing process.
And what about informants? If police use an informant after charges have been filed, does the Sixth Amendment right to counsel come into play? This seems like a potential gray area where police might try to get around the rules.
It can be tricky, yes. A defendant's post-indictment statements made to an informant are inadmissible if the situation was set up by the government to be likely to induce the defendant to incriminate himself without counsel present, end quote. This is where the police actively use an informant to deliberately elicit incriminating statements from a formally charged defendant about the charged offense in the absence of their counsel. It's seen as circumventing the right to counsel. However, police may place an informant in a defendant's cell simply to listen passively to the defendant's statements so long as the informant doesn't engage in active questioning or elicitation about the charged crime. The distinction is between deliberately eliciting a statement versus merely overhearing one the defendant volunteers. The Sixth Amendment protects against state-initiated interrogation, direct or indirect, after charges are filed.
That makes sense. It's about preventing trickery or undermining the lawyer-client relationship once formal charges are brought, and the adversarial process has officially begun. Now, you mentioned the Sixth Amendment right to counsel is also offense-specific. What exactly does that mean, and why is it so important, especially in cases with multiple charges?
This is a crucial concept, often tested. Once the Sixth Amendment right to counsel attaches for a particular offense, it applies only to the specific offense at issue in that proceeding. It does not automatically extend to other uncharged crimes, even if they're factually related or arise from the same incident. So, let's say you're formally charged with robbery, and your Sixth Amendment right to counsel attaches for that robbery. Police cannot question you about the robbery without your lawyer present or a valid waiver. But if, during that same time frame, they also want to question you about an uncharged murder that might have occurred during the robbery, your Sixth Amendment right has not attached for the murder yet because you haven't been formally charged with it. So, questioning about the murder might be permissible under the Sixth Amendment, though Miranda might still apply if you're in custody.
Okay, so how do we determine if two crimes are the same offense for this purpose or for double jeopardy? You mentioned the Blockberger test.
Right. The test commonly used is the Blockberger test, which asks whether each offense requires proof of an element that the other does not. If each has a unique element, they are considered separate offenses for double jeopardy, and generally for Sixth Amendment purposes too. For example, think about robbery, which requires taking property by force, versus larceny, taking property without force. Larceny might be considered a lesser included offense of robbery if all its elements are part of robbery, so they might be the same offense. But robbery and, say, arson committed during the same event would clearly be distinct offenses under Blockberger because each requires proof of elements the other doesn't force for robbery, malicious burning for arson. The counsel attached to that specific crime.
That's a really helpful way to distinguish between offenses and understand the specific scope of the right. So how can a defendant waive this Sixth Amendment right to counsel, and what are the nuances there, especially regarding prior assertions of the right? Can they change their mind?
Yes, like other constitutional rights, the Sixth Amendment right to counsel can be waived. The waiver must be voluntary, knowing, and intelligent. The defendant has to understand the right they're giving up and the consequences. Interestingly, the Supreme Court has held that receiving a Miranda warning sufficiently apprises a person of her Sixth Amendment rights as well, and the consequences of waiving those rights, even though Miranda rights technically arise from the Fifth Amendment. So, a standard Miranda waiver can often suffice for waiving the Sixth Amendment right to counsel during post-attachment questioning, assuming it's knowing and voluntary. Now, even after Sixth Amendment rights attach, police may initiate non-custodial interactions with the accused outside the presence of her lawyer. The Sixth Amendment protection is primarily against deliberate elicitation in a custodial setting or other critical stages once invoked.
Wait, that last point seems counterintuitive. If the right has attached, why can police still talk to them outside their lawyer's presence if it's non-custodial?
It's because the Sixth Amendment is primarily focused on protecting the defendant during formal adversarial proceedings in critical stages, especially custodial interrogation. If the interaction is truly non-custodial, the coercive pressures are seen as less significant. However, if the accused has actually asserted the right to counsel for that specific offense, meaning they explicitly told the police or a judge, "I want a lawyer for this charge," then subsequent waivers for that same offense are presumed involuntary. But this presumption typically only applies in a custodial setting. The Supreme Court wants to ensure that once a defendant clearly states they want a lawyer for a charge, that request is honored robustly, especially when they're in custody. In contrast, if the accused has not actually asserted the right to counsel, for example, if the court automatically appointed counsel at arraignment without the defendant explicitly requesting it, then there is no presumption that any subsequent waiver of this right was involuntary, even in a custodial setting. They still have to show the waiver was knowing and voluntary, but the government doesn't have that extra hurdle of overcoming a presumption.
And what if a defendant decides they don't want a lawyer at all? Do they have a right to represent themselves, to go it alone?
Yes, absolutely. A defendant has a constitutional right, under the Sixth Amendment, to refuse counsel and proceed pro se, meaning represent himself, at trial. This is a fundamental right established in Ferretta v. California. However, exercising this right comes with significant risks. When a defendant chooses to proceed pro se, the court should warn the defendant of the dangers and disadvantages of doing so, like navigating complex rules of evidence and procedure, and may appoint standby counsel to be available to assist the defendant if requested, or potentially take over if the defendant's self-representation becomes completely unmanageable or disruptive. And keep in mind, even when the defendant has validly waived his right to counsel, any statements made during interrogation must still be voluntary under the Due Process Clause to be admissible at trial. The government cannot use compelled statements, waivers, or no waiver.
Now, let's talk about the remedies for denial of the Sixth Amendment right to counsel. What happens if this crucial right is violated? The consequences here are often quite severe, right? More so than some other violations.
They absolutely are, particularly if the denial occurs at trial. A defendant's conviction will be automatically reversed for the denial of counsel at trial, even without a specific showing of unfairness or prejudice. This is considered a structural error, because the presence of counsel is deemed so fundamental to a fair trial that its complete absence makes the entire trial fundamentally unfair, rendering the outcome unreliable, regardless of the evidence of guilt. Similarly, if a defendant is denied counsel and enters a guilty plea, they generally have the right to withdraw that plea, and the plea cannot be used against them later as an admission. The lack of counsel taints the plea itself. For a denial of counsel at a non-trial proceeding, however, like maybe a preliminary hearing, it's typically subject to a harmless error analysis. The conviction will only be reversed if the error actually affected the outcome of the case. This shows the court's hierarchy of rights, with the trial right being paramount.
And does the exclusionary rule, our old friend, apply to Sixth Amendment violations? Or is it like the Fifth Amendment Miranda rule, where it's a bit more limited in terms of physical evidence?
This is another key distinction you need to remember. The fruit of the poisonous tree doctrine does apply quite broadly to exclude any statements or physical evidence obtained as a result of a Sixth Amendment violation.
Punto.
So, if police illegally question a formally charged defendant without their lawyer present, or a valid waiver, and the defendant reveals where evidence is hidden, both the incriminating statement and the physical evidence found as a direct result of that statement would likely be excluded under the Sixth Amendment. This is a broader exclusion than for a mere Miranda violation, where the physical fruit might come in. However, just like with the Fourth and Fifth Amendments, there's an impeachment exception. Incriminating evidence obtained in violation of the Sixth Amendment may still be used for impeachment purposes if the defendant chooses to testify at trial and contradicts that evidence.
Okay, let's really unpack this now. This is a crucial distinction that bar exam questions absolutely love to test. Comparing the Fifth Amendment right to counsel, the Miranda right, and the Sixth Amendment right to counsel, you absolutely need to know the specific triggers, scope, and implications for each to avoid costly mistakes on an essay or multiple choice.
Absolutely. And what's fascinating here, and helpful for remembering the rules, is how the underlying rationales differ, which explains why the rules are distinct. The Fifth Amendment right to counsel, the Miranda right, is designed to protect against compelled self-incrimination, particularly during the inherently coercive atmosphere of police-dominated custodial interrogations. It's really about protecting the integrity of the individual's choice whether or not to speak to the police when under pressure. The Sixth Amendment right to counsel, however, is designed to ensure fairness in the adversarial process itself once the government has formally committed to prosecuting an individual by filing charges. It's about ensuring the defendant has a skilled advocate to navigate the complexities of the legal battle and ensure a level playing field against the state.
So let's break down the key distinctions, maybe based on that comparison table logic. First, applicability. When does each right apply? What's the key trigger for each?
Okay. The Fifth Amendment right to counsel applies only when a suspect is both, 1, in custody, and 2, subject to interrogation. Both conditions must be met. It's tied to that specific coercive police environment. The Sixth Amendment right to counsel, on the other hand, applies. 1, when formal judicial proceedings commence, like indictment, information, or arraignment, and 2, only during critical stages of prosecution after that point. It's tied to the formal legal process itself.
And what about making the request? Does the suspect have to specifically ask for a lawyer for each right, or is one automatic?
This is a big difference. For the Fifth Amendment Miranda right to counsel, an unambiguous request is required. If you want a lawyer during a custodial interrogation, you have to clearly state it. As we discussed, just staying silent or making an ambiguous comment isn't enough. For the Sixth Amendment, generally, no request is required for the right to attach. It attaches automatically once those formal proceedings begin, and the court has an obligation to appoint counsel for indigent defendants at critical stages, whether they ask or not. It's a fundamental procedural right that kicks in automatically.
And waiver. Are they treated the same, or are there differences in how a defendant can give up each right, especially after asking for a lawyer?
Both waivers must be knowing, intelligent, and voluntary. However, the rules surrounding subsequent waiver after invocation differ significantly, particularly in custodial settings. As we discussed, once the Sixth Amendment right has actually been asserted by the defendant for a specific charge, subsequent waivers for that charge while in custody are presumed involuntary, a tougher standard than for Miranda generally. This stricter rule for the Sixth Amendment is tied to its purpose of ensuring fairness once the formal adversarial process is underway.
Beyond just having a lawyer appointed or retained, the Sixth Amendment also guarantees the right to effective assistance of counsel. This isn't just about having a warm body sitting next to you. The lawyer has to actually be competent. But proving ineffective assistance is notoriously difficult, right? There's a very specific, high legal test.
That's right. It's the Strickland v. Washington test, named after the Supreme Court case. And it's a demanding two-pronged standard that the defendant must meet to prove their lawyer's assistance was constitutionally ineffective. And baseline starting point is that reasonable competence is presumed from defense counsel. Courts are highly deferential to lawyers' strategic decisions, so the defendant has a very high bar to clear to overcome this presumption.
And what are those two prongs that the defendant must show? What do they mean in practice?
Okay, prong one is deficient performance. The defendant must show that counsel's representation fell below an objective standard of reasonableness under prevailing professional norms. This means the lawyer made errors so serious that counsel was not functioning as the counsel guaranteed by the Sixth Amendment. It's not just bad strategy, it's performance outside the wide range of professionally competent assistants. An example the Supreme Court used in a later case is if counsel failed to inform a non-citizen defendant that pleading guilty carried a clear risk of automatic deportation. Prong two is prejudice. The defendant must show that counsel's deficient performance prejudiced the defendant, resulting in a reasonable probability that, but for counsel's unprofessional errors, the result of the proceeding would have been different. Reasonable probability means a probability sufficient to undermine confidence in the outcome. This means the lawyer's screw-up actually had to affect the outcome of the case, whether it was the trial verdict or maybe a sentencing decision. It wasn't just a harmless error.
So it's not enough that the lawyer messed up. That screw-up actually had to be significant enough that it likely changed the outcome. A tough standard. But there's an exception, right? Are there situations where prejudice is presumed, where you don't have to prove the outcome would have been different?
Yes, prejudice is presumed in a few limited circumstances. Most notably, if counsel's deficient performance actually or constructively denied the defendant counsel altogether at a critical stage, or if it cost the defendant an appeal that they otherwise would have taken. The court views the complete loss of an appeal due to lawyer error as so fundamental that prejudice is automatic. However, it's really important to note what is generally insufficient to establish ineffective assistance. Mere inexperience, choice of questionable trial strategy, or failure to produce certain mitigating evidence unless it was completely unreasonable not to investigate. The bar is set high to avoid endless second-guessing of every tactical decision a lawyer makes during the heat of trial, as hindsight is always 20/20. Courts give wide latitude to reasonable strategic choices, even if they ultimately fail.
That makes perfect sense. Lawyers make strategic calls all the time, and not every losing strategy means the lawyer was constitutionally ineffective. What about conflicts of interest? That seems like a clear way counsel could be ineffective if their loyalty is divided.
It definitely is. The representation of defendants with conflicting interests may amount to ineffective assistance of counsel, violating the duty of loyalty. To prove this based on a conflict, the defendant generally must show both. One, that the representation involved an actual conflict of interest, and two, that the conflict adversely affected counsel's performance. An actual conflict arises when counsel is subject to an obligation or unique personal interest that, if followed, would lead counsel to adopt a strategy other than that most favorable to the defendant. A classic example is representing two co-defendants whose defenses are antagonistic. Helping one might hurt the other. An adverse impact occurs when a plausible alternative defense strategy or tactic might have been pursued but was inherently in conflict with or not undertaken due to counsel's other loyalties or interests. Unlike the Strickland prejudice prong, the defendant usually doesn't have to show the outcome would have been different, just that the conflict negatively impacted the lawyer's choices. It's a challenging standard, but vital for preserving the undivided loyalty owed by counsel to their client.
Okay, we've covered the big three amendments in detail. Now let's move into the general flow of a criminal case, starting with pretrial procedures. These are all the important steps that happen before the actual trial begins. First up, eyewitness identification procedures. These are incredibly crucial, as we know from research. They can be prone to error, yet they can be incredibly persuasive to a jury. What are the different types and the rules surrounding them?
Indeed. Eyewitness testimony is powerful but fallible. There are two main types of pretrial identification procedures. Corporeal identifications, which are done in person, like live lineups where the suspect stands with fillers, or one-on-one show-ups, and non-corporeal identifications, which are not done in person, most commonly photo arrays where a witness looks through pictures. The Sixth Amendment right to counsel, which we just discussed, applies specifically at corporeal identifications like lineups or show-ups, but only if they occur post-indictment or after formal charges have been filed. This is because the physical lineup after formal charges is considered a critical stage where a lawyer's presence can help ensure fairness and detect suggestiveness that might taint a witness's later in-court identification. The right does not apply at pre-indictment lineups or any non-corporeal identifications like photo arrays, regardless of timing.
And if that Sixth Amendment right to counsel at a post-indictment corporeal lineup is violated, what's the remedy? Does the witness just never get to identify the defendant?
If the right to counsel is violated at that post-indictment lineup, then evidence of the lineup identification itself is inadmissible at trial. It's excluded. However, the witness might still be allowed to identify the defendant in court during the trial if the prosecution can prove by clear and convincing evidence that the in-court identification has an independent source, or independent reliability, meaning the witness's memory of the defendant comes from their observation at the crime scene and is untainted by the illegal lineup procedure. The court will look at factors established in Neal v. Biggers, like the witness's opportunity to view the criminal at the time of the crime, the witness's degree of attention, the accuracy of their prior description, the level of certainty demonstrated at the confrontation, and the length of time between the crime and the identification confrontation.
Okay, so there's the Sixth Amendment challenge. Is there another way to challenge an identification procedure?
Yes. Separate from the Sixth Amendment right to counsel, any pretrial identification procedure, whether corporeal or non-corporeal, pre- or post-indictment, can also be challenged under the Due Process Clause if it was impermissibly suggestive. This is a two-pronged test, and the defendant must prove both. 1. The identification procedure itself was impermissibly suggestive, meaning it was conducted in a way that unfairly pointed the witness toward the defendant, like having the defendant be the only one wearing clothing described by the witness. And 2, there was a substantial likelihood of irreparable misidentification as a result of that suggestiveness. This second prong focuses on the reliability of the identification itself, using those same Biggers factors. If it was suggestive but still reliable, it might be admitted. If it was both suggestive and unreliable, it violates due process and must be excluded. So you potentially have two avenues to attack a pretrial identification: a Sixth Amendment counsel violation for post-indictment corporeal lineups, or a 14th Amendment due process violation based on suggestiveness and unreliability for any procedure.
So the procedure itself has to be fundamentally unfair and likely lead to a mistake.
Okay, what about preliminary proceedings in general? These are the very early steps after an arrest, but before a potential trial.
Right. Under the Fourth Amendment, if a defendant is arrested without a warrant, a Gerstein hearing, a prompt preliminary hearing, must generally be held, usually within 48 hours, to determine whether probable cause exists to continue holding the defendant. This is only required if that probable cause determination has not already been made by a neutral magistrate, for instance, through a grand jury indictment, or the issuance of an arrest warrant before the arrest. The point is to ensure that no one is detained for long without a judicial finding of probable cause. Other common preliminary proceedings can include an initial appearance, where the defendant is formally informed of the charges and advised of rights, and maybe bail is set, an arraignment, where the defendant enters a formal plea, like guilty or not guilty, and possibly a separate detention or bail hearing to decide if the defendant will be released pending trial. And speaking of detention, what about the right to bail? Does everyone automatically get bail? Is it a constitutional right?
Actually, there is no constitutional right to bail itself under the Eighth Amendment. The Eighth Amendment only prohibits excessive bail, not the denial of bail altogether in certain circumstances, like capital cases or where the defendant poses a significant flight risk or danger. However, any denial of bail or the setting of excessive bail must comply with the Due Process Clause, meaning the decision cannot be arbitrary or discriminatory. If bail is set, it must be reasonable in relation to the legitimate government interests, primarily ensuring the defendant's appearance in court. It's not supposed to be used as punishment before conviction.
What about a defendant's competency to stand trial? This sounds different from pleading insanity.
It is entirely distinct from an insanity defense, which relates to the defendant's mental state at the time of the crime. Competency to stand trial relates to the defendant's present mental capacity during the proceedings. The standard requires that a defendant